9 o'clock. We'll go ahead and call a meeting to order. We'll start off with an opening prayer from Mr. Morris.
Let's stand for prayer. Let's pray. Dear Heavenly Father, thank you for waking us to a new day. Thank you for all your many blessings and have bestowed on us. I ask you for wisdom, guiding, and conducting business for Jackson County and leading us to make the best decision. In Jesus' name, amen.
Amen. Amen. Thank you. This pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. That brings us down to amendments to the agenda. I don't have any. Mr. Morris?
I don't have any.
Mr. Taylor?
I have a question, if I may.
Sure.
The very last item on consent agenda is Port of Pascagoula joint resolution approving some rental of the buildings to the Coast Guard. Is anyone familiar with that? I've asked questions and I've gotten no answer. And I want to be sure that we're aware of what we're agreeing to here.
You want to pull it? And
And probably pull it.
Okay, and put it under discussion. Let's put it under, we put it under action items, can't we, Brian? Item C? Yeah, let's make it item C under action items. That it, Mr. Taylor?
That's it, I'm sorry. Yes.
Okay. Mr. Ross?
None.
Mr. Beausard?
None.
Mr. Eldridge is not here. Mr. Fulton?
No, sir.
Mr. O'Neill?
None.
Mr. Palmer?
None.
Are there any others have amendments to the agenda? That being said and done, I'll accept a motion to approve the amendments to the agenda.
I'll move.
I second.
Motion by Mr. Taylor, a second by Mr. Morris. All those in favor say aye.
Aye.
Opposed, no. Next item, we have a notice to increase assessment of the real or personal property. It's a Miss Helen Gilmore Fairley. The address is 15609 Orleans Drive, Biloxi, Mississippi. PIDN number is 05102-107.000. It was published in the Sun Herald. Is anyone here to represent the Fairley family? Anyone to represent Miss Helen Fairley? Okay. I'll make a motion. We pass it as approved, as presented.
Second.
Second by Mr. Beausard. All those in favor say aye. Aye. Opposed, no. Brings us down to general public comments. Anyone here for general public comments? Come on up and give us your name. Just a minute, Jeff. I'll bring you up next. Go ahead. Yes, sir. Give us your name and address, please.
My name is Harry Lloyd Holston, Jr., and my address is 8708 Coleman Homestead Road, Moss Point, in the Hurley community.
Okay. Go ahead, Mr. Host.
As a citizen of this county, I should be able to enjoy the safety and comforts of my home without interference from preventable outside influences. On or around July the 4th of each year, a community fireworks show is staged by the leadership of the Full Life Assembly of God Church in Hurley. This event draws a large crowd, several hundred people. During the fireworks show, which lasts approximately 1 hour, debris from the remnants of the exploded fireworks falls to the ground to an area described by professionals in the industry as the fireworks fallout zone. This zone specifically refers to the area surrounding where the fireworks are launched, where the spent casings, embers, plastics, and paper fragments fall to the ground after exploding. Unfortunately, my home and property lies in the fireworks fallout zone of Full Life's yearly display. On the evening of July the 3rd this year, The annual fireworks show was staged from the backyard of my neighbor's residence located at 8616 Coleman Homestead Road. The next morning on July the 4th, I observed the remnants of the exploded fireworks on my driveway, in my yard, around my pecan trees, on the deck of my pool, and in my pool. The Jackson County Sheriff's Department was called. Deputy Dustin Muffley made a report on what he witnessed. At approximately 10 a.m. on the morning of July the 4th, I contacted Reverend Jimbo Reed, the occupant of the above address, and asked that he please come to my home to witness for himself the firework remnants on my property. He cordially complied, then offered to pick up the charred casings, plastics, golf ball-sized pieces of a hard rock-like substance, sweep the many pieces of paper from my yard, use a blower to remove the paper fragments from my pool deck, and offer to pay for a professional pool company to change the pool filters and vacuum my pool. This conversation took place again on July the 4th at approximately 10 a.m., a day my family and I had planned on enjoying our holiday and our pool. The same morning on July the 4th, Reverend Reed used a riding lawnmower, which pulled some sort of a sweeper apparatus, to sweep the lawn, while a Mr. Goff picked up and raked trash. Together, they entered the gate of my pool area and blowed paper fragments from exploded fireworks off my pool deck. Gentlemen, please remember this was a day my family and I should have been able to enjoy our holiday at our home. Through no fault of our own, we were interrupted by two gentlemen cleaning up firework debris. However, not nearly all of the trash was picked up. Approximately 2 to 3 hours after they left, I picked up more trash that they had left behind. It happens every year. I was reluctant to allow my 5-year-old grandson and our family into the pool due to observed dissolved firework remnants in the water. At this point, the question becomes, what is the remedy to correct this problem that occurs year after year? I will respectfully propose the following. Number 1, move the fireworks display to a place where my home or anyone's home is not in the fireworks fallout area. I have asked Reverend Reed in past years to do this. He has not. Number 2, adopt an ordinance to prohibit the staging of a public fireworks show from a private residence. A public fireworks display can be defined as an event where fireworks are intentionally discharged for the entertainment of the public who are either invited or allowed to view the display. An ordinance such as this will aid in safeguarding the Constitution-guaranteed rights a homeowner expects to enjoy at his home. This morning, I am asking you to implement an ordinance that would prohibit the staging of a public fireworks display from a private residence. I would appreciate a response from this board within 60 days of today's meeting. Thank you. But I have a handout. If I could, I'd like to give each member of the board.
Yeah, that's fine. Just started it in, come around, Mr. Taylor.
Thank you.
Thank you, sir. Thank you.
Thank you, sir.
That it?
That concludes it.
All right, thank you, Mr. Holston. Anyone else here for general public comments? Come on up, Jim.
Good morning. I think most of you know me, but my name's Jeff May. I'm with Michael Baker International. And I wanted to come before you this morning and introduce one of our newest staff members, It's Jackson Rester. Jackson is a Jackson County resident. Grew up in Ocean Springs, went to Ocean Springs High School, went on to finish his degree in civil engineering at Mississippi State University, and then decided to come back home. You know, we always hear like we educate our youth and they move off and they go back, but Jackson came back home, so he's working with us and he's working on a lot of y'all's projects. So just wanted to make a formal introduction, so if y'all see him in the hallway, you know what he's doing.
Great. Well, that's good. Thank you.
Hey,
Thank you,
Jeff,
Jack.
while you're there, I'd be remiss if I didn't get an update on
I was
Beachview.
expecting one.
Yeah.
It's actually going real well. You know, we've moved down south, I guess north of Palmetto, and they're in that area now. All the sidewalk and curb are in between Blueberry and Palmetto, and then just continuing north.
When do you think they'll pave?
I'll probably wait and do that last, so it's one smooth motion.
Are we still on track for
We're
the
still on
target
track.
date?
Yeah,
Okay.
still on track.
Okay,
So
and I
they're
appreciate
moving ahead, and, you know.
Oh, they're
knock
making
on
great
wood,
progress. I'm
we've
really
had
impressed.
We've had some
Yeah.
good road construction weather here lately,
Yeah.
so,
They taking advantage of it too.
That's
I
right.
appreciate that.
That's right.
All right,
Right.
thanks.
thank y'all.
Thank you, Jeff. Anyone else for general public comments? All right, that brings us down to consent agenda. We'll get a motion to accept it as amended. Second. Have a motion by Mr. Morris and a second by Mr. Taylor. All those in favor say aye.
Aye.
Opposed, no. Thank y'all. Let's swap over. That brings us down to department heads. Mr. Elmore.
All right, good morning, gentlemen. We're down to this usual time of year, and I wanted to mention that here with us this morning, of course, we've got Mary Martha Henson with Economic Development. Y'all know her. Andrew Hinkenbein, of course, from Bollinger, and Mr. Jack Norris from Ingalls here as well. So,
Good.
but the first request that you guys have there is from Bollinger, Mississippi Repair.
All right, I'll make that motion. Second. Have a second by Mr. Taylor. All those in favor say aye. Aye. Opposed, no.
All right, the next one is from Bollinger, Mississippi Shipbuilding.
So moved.
Motion.
Mr. Beausarge, you heard him first, and a second by Mr. Morris. All those in favor say aye.
Aye.
Opposed, no.
All right, the next one is from Chand, Mississippi LLC.
Have a motion by Mr. Taylor,
Second.
second by Mr. Ross. All those in favor say aye.
Aye.
Opposed, no.
All right, next you have the request from Chevron USA.
So moved. I'll make the motion.
Second.
By Mr. Taylor. All those in favor say aye.
Aye.
Opposed, no.
All right, next you have Huntington Ingalls Incorporated.
Make that motion.
Have a motion by Mr. Morris. I'll second. All those in favor say aye.
Aye.
Opposed, no.
And lastly, you have Superior Optical Labs.
So moved.
Have a motion by Mr. Beausarge.
Second.
Second by Mr. Ross. All those in favor say aye.
Aye.
Opposed, no.
All right, that's it, thank you.
Thank you, Nick. Ms. Wells, claims docket. Come on up.
Good morning. The first item I have is the order approving the claims docket.
So move.
Second.
Second by Mr. Ross. All those in favor say aye.
Aye.
Opposed, no.
And the last item I have is the resolution authorizing the interfund loans for September 30th, 2025.
I'll move.
Have a motion by Mr. Morris, a second by Mr. Taylor. All those in favor say aye.
Aye.
Opposed, no.
Thank you.
Thank you. Ms. Barnett?
Good morning. I have a resolution authorizing the intergovernmental transfer of K-9 Marcos to the Mississippi Department of Corrections.
Okay.
Yeah. Can I ask, what's going on with that?
Do I?
Let me, if I can, Sheriff, can you
Hey, yeah.
shed
sure.
a light?
Yeah.
Let me, before he explains it, this came to the legal department and we looked at it. And legally, we drafted up the resolution where we can transfer the K-9 to the Department of Corrections. We used a couple of different statutes because we're selling two things. We can sell to another governmental entity at below fair market value, or we can give something away or get rid of something, so to speak, if it has zero value. So we actually kind of use a couple of different statutes to make this legal, and to make sure that this K-9 had a different home. So Sheriff, if you can kind of explain, because it is a little bit of an unusual
It is.
situation.
I've never run across a situation like this. Marcos is a Belgian Malinois that is very large. Purchased him 4, 5, 6 years ago. I don't know, we purchased him with asset forfeiture money, so no taxpayer money was gone to purchase this K-9. And when we requested this particular K-9, we wanted him to work alongside of our tactical team. So we had some extra training, and Marcos had an extremely high drive, and he was, on top of being a large dog, he had a lot of demands when he was off duty. And of course, the K-9s live at home with their handlers off duty. And this is a situation unlike I've ever seen. Marcos tore up about everything that he was put in. And he was not a K-9 that could be just let roam around the house with a family. We purchased kennels that he tore up when the weather got bad. He would hurt himself trying his best to get out of whatever container that he was in at the time, fence or kennel or whatnot. And it was a really taxing on this deputy's family, who has 2 young kids. And it just got to the point where he wasn't complaining, but we saw what was going on with his family. So I think the priority of a good family life for one of our deputies, and to prevent this dog from hurting himself. We already had his teeth checked out because he just tears things up. So that was the best decision, and we learned that MDOC, in between the fences at the prisons, has dogs that they tend to that help guard the complex, and Marcos would be a good one for that. So we went and followed up with that process, and I think that was the best decision that we could make at the time on this particular K-9.
Understood. He did a good job on the job,
He did.
but at home, it was just almost an impossible situation.
It was.
I've been told these dogs are extremely high-strung, aren't they?
Malinois are the
This
worst.
this one was above and beyond anyone that I've ever seen or that our department has. So that's what I think that was the best decision at this time. And luckily, we were able to locate or relocate the dog to another entity that can use him and that can utilize him better. I think the situation in which he's going to would be best suited for him, other than inside of a home or outside of a home at a residence with a young family. So
Okay.
that's the reason for that. So, any questions?
I understand. I'll make that motion.
All right.
Have a motion by Mr. Bossarge,
Second.
second by Mr. Morris. All those in favor say aye.
Aye.
Opposed, no. Thank you. Oh, come on up. I started to say Earl, but no, Earl's not here today.
He's getting his hair done this morning.
Yeah.
Good morning. Just a quick update on the Office of Emergency Services. We're starting to wind down with a lot of our renovations and big projects. The new driveway at Station 18, which is there on 63 by Plant Daniels, has been installed. Contractors are currently finishing up the new roof on Station 5, which is there on St. Martin Street, St. Martin. The new EOC is progressing very well. I drive by it on a daily basis. Stopped by last week and spoke with the contractors, and they've advised me that they're tired of sweating, so they're going to be finished up next month. I'm wishful thinking, right? We began the process of moving into Station 22, which is, as you guys know, is the new station there on Saracena Road. Trucks have been placed, and we're in the process of having appliances, furniture, generator, and all that installed at that station. And as always, with your continued support, we plan to hire 3 personnel to man that station come October. Took delivery of our new Danco in June. That truck was put in service as Engine 3. and is housed at our Station 3 in Latimer community. An interesting fact about that truck is just a few short hours after it was placed in service, it was first in at a house fire in the Latimer community. So that seems like a common trend for us here in this agency. For some reason, when we put new trucks in service, they go right to work. Members of our office are scheduled to travel to Sioux Falls to do the final build inspection on the new Spartan engine that we have ordered. That will happen in the middle of August. We have plans to hopefully have that truck in service in the Hurley community, Station 17. So another good thing we're looking forward to. Last week we met with the National Guard. Several members came by our office and we discussed their roles and responsibilities in large-scale response, things like air support, pod sites or points of distribution, search and rescue. But I felt a topic that we landed on was very interesting. As these fine men have traveled through the lower 6 counties, I think they've determined the need for shelter staffing. I think it's a complaint that a lot of us are having. When we're trying to open these shelters and meet the demands and the needs of our citizens, it's hard to keep up with that demand at times. So I felt it very interesting that they're actually looking at putting shelter staffing teams together to help in areas like Jackson County when, we need to stand up, 2 or 3 shelters and don't have the volunteers to do so. They're looking at composing teams to be able to come in and help us with those situations. So it's very interesting. We'll see what comes of it. They plan to work on it, and, we've told them that we'd like to meet again to discuss where this is going to go, so we'll see where it takes us. And last, as I know each and every time me or Earl comes in here, we always say thank you, but again, thanks to each and every one of you, Matt, Joe, Kelly. I mean, there's a lot of people in this community that play a huge part in our success, so again, thank you very much. Any questions for me? All right, have a great day.
Thank you, Larry.
Thanks.
That brings us to item number 9, which is a planning appeal, and it's scheduled for 10 o'clock, so we'll go around it, and it'll bring us down to action items. Brian, you have anything on
I do. I have a couple quick things on state issues. There were some new laws that were passed that went into effect July 1st. One of those was the Safe Solicitation Act, which requires people to get a permit if they want to solicit for funds or anything of value on county-owned property, I guess, within intersections. And we've been working with Planning Department and trying to develop a permit application and also a permit form for that to occur. The law allows us to charge up to $25 per day to get a permit to do that work. And so we're working on that. Had a brief discussion with the Sheriff's Department about it during our budget meeting. And as soon as we get our permit put together, we're going to have another meeting with them just so that everybody's on the same page. And we'll make an announcement as to when we're going to start doing the permits. That kind of went hand in hand with another law, was the urban camping law that went into effect. And I think those two things are going to kind of work hand in hand to try to clean up some of the situations that we see at major intersections within the county. Also talked with the city of Moss Point about that, and our permit will likely be good for intersections within Moss Point or in the unincorporated part of Jackson County. I assume the other cities are going to be working on something similar to that. There's been some discussion as to where we sell those permits, and the Planning Department is what we've decided so far, unless someone has an objection to that, and they would be sold here in Pascagoula in this building at the Planning Department. Secondly, on the federal issues, sent an email out to the board last week and to some others, which was kind of a summary of what was in the one big bill that was passed in Congress last week or a couple weeks ago. I think there's a lot more to that bill, but the summary was a good one, I thought. Also, we're gearing up to visit with some of the staff during the summer recess. We've already got some dates scheduled for some of Congressman Ezel's staff to visit with us and talk about projects and things that we have going on. and others. So just wanted to let y'all know that. And when we get closer, I'll send out the date so y'all know exactly when they'll be here.
Okay.
That's it.
Mr. Mike's staff's coming here?
Yes, they'll be
good.
here in our office in a few weeks.
That's good. I like it with them coming here. Anyway, thank you, Brian, I appreciate it. And next up will be item C, which we moved, is a joint resolution between Jackson County Board of Supervisors and Jackson County Port Authority approving the USCG buildings with the numbers here sublease agreement. Did you have some questions, Mr. Taylor?
Well, yeah, I was curious if we know exactly what that's for, because I don't recall. I've read it. It appears to be apparently about a 1 year with 19 one-year renewals of buildings that are being leased or subleased to the Coast Guard.
Mm-hmm.
But I've not seen anything that we've even discussed it.
Right, that came to legal as these type of joint resolutions with the court normally do. From a legal standpoint, we're fine. It is a sublease. The port has actually already approved it, I believe. I don't know if I sent it to Brian or Brian picked up on it himself as far as the terms. Did he agree with the terms of the lease? But it's a standard sublease that we would normally sign off on along with the Port Authority. And that's basically what it is, Mr. Taylor. Yeah.
Okay. It's nothing new or different, it's just kind of what we've been doing.
Right, right. The county is required to sign off on this, approve it, shall I say, along with the Port Authority, so.
Okay, so we were notified.
I'm sorry?
We were notified.
Yes, so through the legal department, it kind of came through the normal channels that it would come through, and typically it gets put on consent, although these things could certainly be put on the regular agenda for discussion, whatever the board wants to do.
Okay, well, if there is any further discussion, anyone who wants to speak, if not, I'll make a motion that we approve it.
Second.
We have a motion by Mr. Taylor and a second by Mr. Beausarge. All those in favor say aye.
Aye.
Opposed, no. Thank y'all. All right, that brings us down to supervisor items. I did not have anything. Mr. Morris?
Yes, I
you
have a
some?
resolution to accept the resignation of Alina Harper from the Board of Commission to the U.S. Regional Housing Authority. Number 8, I make that resolution, to accept her resignation.
All right, I'll second.
Thank you. I have a resolution appointing Ms. Beverly Cook.
Let's vote on the first one.
Okay.
All those in favor say aye.
Aye.
Opposed, no. Okay, go ahead, Mr. Morris. I'm
Yeah,
sorry.
I have a resolution to appoint Ms. Beverly Cook to the Regional Housing Authority, number 8. I make that motion.
Okay. Second by Mr. Taylor. All those in favor say aye.
Aye.
Opposed, no. All right. Mr. Taylor, you didn't have anything else, did you?
No, sir.
All right, Mr. Ross?
Nothing.
And Mr. Beausarge?
No.
All right, thank y'all. That brings us down to closed session. Let's see for sufficient evidence to stay in executive session.
Yes, Mr. Cummings, we have a number of items. Got a potential litigation issue regarding a zoning matter, potential litigation regarding Pascagoula annexation. We've got a discussion regarding the relocation or expansion of the business in Pascagoula, pending litigation, Jackson County versus George County, potential litigation with regard to a notice of claim that we received in the legal department. And then Mr. Fulton has a couple of potential litigations, one regarding business in Moss Point and one regarding a code enforcement issue.
Okay?
Make a motion to stay in closed session to determine if we need an executive session.
Second.
Have a motion by Mr. Beausarge, a second by Mr. Morris. All those in favor, say aye.
Aye.
And opposed, no. Thank y'all. That brings us down to closed session. Oh,
The support boards in my office. 'Cause they're
All right.
Okay.
Are we ready?
Yeah, let me announce what we've done. I'll announce what we've done in.
Okay, go ahead.
Yeah. In executive session, the board took action on several matters. First, the board passed a resolution of the Board of Supervisors of Jackson County opposing the proposed annexation of areas of Jackson County by the city of Pascagoula. The board made a motion to approve the settlement order as presented in the case of Jackson County versus George County and Singing River Mental Health, Chancery Court, George County, Mississippi, cause number 24 CV 300. The board approved a resolution of the Board of Supervisors of Jackson County, Mississippi, withdrawing from Singing River Mental Health, Mental Retardation Services, Region 14. The board accepted the resignation of Josh Eldridge as commissioner appointed by Jackson County to the Singing River Mental Health, Mental Retardation Services, Region 14 Board of Commissioners, effective immediately upon the filing of the settlement order. The board passed a resolution of the Board of Supervisors of Jackson County, Mississippi, authorizing an appropriation to Singing River Mental Health, Mental Retardation Services, Region 14. That's the old bank account of $200,000 in order to pay outstanding vendors as part of the settlement agreement.
All right. Thank you, Mr. Conley. Marcus, go ahead.
Well, good morning. On April the 16th meeting, the Planning Commission heard the application of Jamie Stedbley. This was an application to allow a small number of hens to remain on the property for personal use and emotional support. The property is at 13809 El Benito Drive in the St. Martin area, and this property is zoned R1. It's only 0.03 acres in size. Of course, the Planning Commission voted 6-0 to deny the application for her to have the chickens. Ms. Steadley is the appellant, and we had several people that spoke against it, and I'll let her take over the meeting.
Forgive me, I broke my leg just shy of 4 months ago, and while I'm moving around much better than I did back in April.
Just like Planning Commission, everyone will give their name and address.
Of course,
for the
yep,
record.
of course. Just need 1 second to get organized here. For the purposes of the record, my name's Jacqueline Wrigley. I represent Mr. and Ms. Stebley on this appeal. Give me just one more moment. Just have my own notes out here. I can tell you that when I went to law school almost 15 years ago, I didn't ever anticipate that I would be making an argument for someone to maintain therapeutic chickens. But that just goes to show you, you never say never. Nope. So here we are today, and I'm almost complete getting organized. Let me pull up one more thing. Oh, no, I'm good. I'm just populating my outline here, you know.
Okay, you want to put it on?
No, this is all right. This is just my notes so that I don't get too, I have a tendency to talk too much, as I've been told, and I have a tendency to talk too fast. So feel free to throw something at me if that occurs this morning. But as I mentioned, my name's Jacqueline Wrigley. I have the honor of knowing many of you up here, so it's nice to see some familiar faces this morning. As I noted, and as Marcus already gave the primer, I represent Mr. and Mrs. Stebley, who are residents of 13809 East El Benito Drive, in response to the Planning Commission's denial of a special use permit on April the 16th for them to maintain a small flock of therapeutic chickens at their home. Since the Planning Commission's decision in April, time went on. We submitted our appeal, given the constraints set forth, both, I guess, from an ordinance standpoint and the regulations that govern these type of things. But then, as luck would have it, last week or the week before, I guess, I was at the Bar Convention in a session hosted by Bubba Pierce, former Justice of the Mississippi Supreme Court, and he started to talk about recent cases coming out of the Court of Appeals and the Supreme Court, and he told me about a case that I felt was very relevant to you all. and in the determination that you'll make, that we're asking you to make here today. We submitted a supplement to the appeal, but unfortunately, y'all's packet had already been submitted. So if it would be okay, I'd like to present you all with just a brief packet that includes a few things. If I can start, okay.
Sure.
You right here. You don't need that? Okay.
We need one.
Okay. I brought a bunch, but I just wasn't exactly sure. Start with Mr. Coleman.
Thank you.
Absolutely. Both stars, thank you, sir.
All right.
Ross, how are you this morning? Mr. Cumbus, my hand's
Thank
not
you.
working fast enough, yes, sir.
Gotcha, you're fine.
I hate that Mr. Elders isn't here. I'm sure that this would have been a great entertainment to him on this morning. And Brian, I don't know if you want one, but maybe you do.
I'll take it.
Here
Thank
you
you.
go. All right. So what you'll see here is a few things. One, lawyers love words, so I put a few of those in there for you too to just explain the update here. But then this supplement also details the Sinkfeld v. City of Bridgeland case, in which the Mississippi Court of Appeals reversed a municipality's denial of a similar land use request where the property owner had supplemented her acreage using premises lease with the neighbor. And ultimately what the Court of Appeals determined was that so long as the resident had a possessory interest that met or exceeded the threshold set forth in the ordinance, it meant that she complied with the ordinance. In this case, it had to do with horses, and Bridgeland apparently has an ordinance that specifies the number of acres that you must have per horse. She did not have enough, so she obtained grazing leases from adjacent neighbors, property owners, to bring her total, property up to the statutory amount. And then you'll also see, the ordinance amount, excuse me. Then you'll also see here a lease between Ms. Stebley, Mr. Stebley, and the neighbor who is on the west property line, Ms. Colleen Cutler. She has agreed to lease for purposes of grazing the chickens and understanding sort of the, why the lease is done. It's not for them to build a guest home on. And so she's entered into a lease that brings Mr. and Mrs. Stebley's total property up to 1 acre. So I have just a few things I'd like to go through, but I'll pause to see, if you all would care for more time to review the information that I've just shared with you this morning, because I recognize you did not have the benefit of that information as you were preparing for this appeal this morning, but also to see if there are any questions that I can answer preliminarily before we kind of walk through the big picture argument, I guess we could say.
So at the Planning Commission, this lease hadn't been executed, but between
That's right, they didn't have the
then and
benefit
now-
of this information.
Okay.
We executed effective as of July 1st, but we only were able to pull this together after the very insightful information that the former justice shared with me earlier this month in Sandestin at the Bar Convention.
How many chickens does Miss Stebley own, Jackie?
She has 8 hens on her
8
property
hens?
right now. Yes, sir.
And no roosters.
No roosters.
How big-
So if-
How big was the lot on the last? About an acre.
So to just touch on, where we are procedurally, if you set aside the lease that I've supplemented for you all this morning, the Fair Housing Act does permit, or require, I should say, governments to work with residents to allow them to, use and enjoy their property with accommodation in the event they have a qualifying, mental health issue or physical issue. And in this case, Ms. Stebley is diagnosed as having ADHD, dyslexia, anxiety, not uncommon diagnoses, but these do qualify as disabilities under the law. And so the Fair Housing Act, as implemented and enforced through HUD, takes the position that when governments are confronted with the question of whether a reasonable accommodation under the law is required, they have to go through an analysis. The Planning Commission, as the transcript reflects, did not undergo such an analysis. They did ask, if chickens were included. They did ask if there was a number set forth in the law, but they didn't go through the analysis to determine whether the chickens are medically necessary, whether the request for an accommodation, which is to maintain this small flock of therapeutic chickens, is reasonable under the law. And because they didn't do that, I would submit that from that standpoint alone, their decision was an error. And I'm not, without awareness that these types of things can be complicated, in that we ask a body of elected officials to help navigate what often boils down to just interpersonal disputes. And that's really what we have here for, reasons that are not germane to this process. Mr. and Mrs. Stebley don't have a friendly relationship with the neighbors that are to their north. And those neighbors are the only opposition that Mr. and Mrs. Stebley have had as it relates to their request for the special use permit. And I would just submit to you all that, a personal dispute between neighbors shouldn't influence the process. And the standards are what the standards are. And this board regularly and, for legitimate reasons, does issue special use permits to residents, to your constituents, when the right arguments are made, the right information is submitted. And in this case, Ms. Stebley presented information from her treating medical provider who has acknowledged the benefit of these chickens to her. The Planning Commission did not undergo the requisite analysis. And as a result, I would respectfully ask that their decision should be reversed on that basis alone. We believe that the record contains adequate information that would allow you all to comply with the Fair Housing Act and grant a reasonable accommodation to Ms. Stebley that would allow her to maintain her small flock of well-kept, well-cared for therapeutic chickens. One thing I should add that did arise in the context of the Planning Commission meeting was that the commissioners were concerned that the coop where the chickens lived at the time of that hearing was in violation of potentially a setback, and I believe Mr. Marcus raised that as well. Mr. and Ms. Stebley went ahead and proactively cured that issue. They bought a coop from Tractor Supply as opposed to the one that they had made themselves, and they put it, if not the center of their property, then to the south side of the center of their property. So now the coop is removed from the property line shared with the neighbors in opposition, and any other potential code issue has been cleaned up and cleared.
Okay,
and
so it's on the opposite side now.
I can't say that it's on the opposite side, Mr. Cumbus, but if the property is here, previously it was here next to the neighbors on the north side, and it's now, if the halfway point's here, it's to the south side of the halfway point, but it's not all the way to the south side of the property. Okay. Yes, sir. We do have pictures. Would that be helpful, just to visualize? Okay.
How long have the chickens been there?
About 3 years.
So, and when did the complaint start?
Is this, do you have one that shows the current location? Okay.
Do she have neighbors on the south side of her? Where you talking about she moved the chickens to her?
So the chicken coop it was on the north side of the property, and it has been moved to now it's on the south side. So here's a before that shows where the coop was, and I'll just start this with Mr. Palmer. Sorry, everybody, and then this shows the after, and then she even installed a little like partition just to block the view of the coop. I mean, the neighbors have placed a 8-foot fence on the property line, so that should resolve the issue of them being able to look into the Stebley's yard. But out of an abundance of caution, Stebley's going to have an additional partition just to create as much of a barrier as possible.
Marcus, copies of those pictures.
And to answer your question, Mr. Ross, we dealt with this from a code enforcement standpoint a few months back. We sent a letter to Jamie, and she decided to come to the Planning Commission to try to get approval. So
this was generated because we went to them and said there were some issues, and then she said, I want to do it the right way and go through the process.
That's right.
So correct.
But other than that, this wouldn't have even been here. like, the neighborhood's not completely worried about this.
No, I don't think that any of the other neighbors are worried about this. And as you know, with Gulf Hills being your district, I mean, there are a lot of people with illegal chickens out there, and you all have better things to do than go to track down all of that. I mean, eggs are expensive, but they're not so expensive that you're gonna add extra work to your plate.
I don't know where the rooster is by my house, but he's there every morning when I walk the dog. And
You get up early though, so that's probably all right.
Well, this R1 area, as you know, you have to have an acre in order to have animals. So this is 0.33 acres.
And as a result, we obtained the kind of grazing lease to model the Sinkefeld case of 0.7 acres, which means that the possessory interest in contiguous property, it now exceeds an acre. And so I would submit that it effectively, and of course I don't speak for your counsel who is more experienced than I, but if she has now an acre, that it would almost render moot the notice of a code violation, and it may alleviate you of the need to even make a determination on whether a special use permit is necessary, because now there's compliance with the ordinance. But of course, we would love for y'all to take the affirmative position that these are therapeutic chickens and that she is entitled to them as a reasonable accommodation, and as a result, the special use permit, is issued, would be issued, but that perhaps it's not necessary for that administrative act to occur, because she now has over an acre as a single possessory interest.
Jackie, where is the 0.7 acres at? Is it in someone else's yard?
It is her. So I don't have.
It's no vacant property.
She owns 4 acres. This
Okay.
particular neighbor, and is friends with the Stebleys and certainly supports the Miss Stebly's ability to maintain these chickens.
It's adjacent property.
It is adjacent, and so they're the west boundary line of their property is the east boundary line, I guess, of hers. And so her 4 acres touches that backside of the Stebly's property. So their yard, by all intents and purposes, now extends an additional 0.7.
They moved the fence and all that stuff.
So right now, we're trying to decide exactly what this means mechanically. I mean, I think I would take the position that if she has a full acre, then where the chickens are placed may not matter, because she has the acre, and the ordinance just simply says that so long as you have at least an acre, you can have chickens in an R1. But we're looking at, does it make sense to enclose part of that area differently? We just wanted to come to you all first and sort of understand the position of the Board of Supervisors before they took any further efforts. And then this all happened pretty quickly, like I said, returning from the bar convention, and then we realized that the Court of Appeals had actually reviewed an issue similar to this, and I felt like it would be instructive for you all to have the benefit of that.
What do you have something on that?
Answer that. She's leasing 0.7 acres from a neighbor, but it's not combined with her parcel. So her parcel is 0.33, so that's why we're here, is because her parcel is not large enough. Now, our ordinance doesn't say it has to be a combined 3.3, but I mean, we work off a parcel, so unfortunately, her parcel is 0.33, so we have to get through this process to make it right for that parcel.
Sure, and again, I believe that the law and the facts are on our side as it relates to a substantive appeal from the the Planning Commission's decision from April 16th, but the Sinkefeld case did take up an issue similar to what Mr. Marcus just explained, and it took the position that, it could be cobbled together by more than one parcel to meet that lot threshold, unless the ordinance specifically said that wasn't how it would be done. And so from the logistics of enforcing these things, I think Marcus is absolutely right. But from the perspective of the Court of Appeals, it does not matter if this is one lot, if it's consolidated into a lot, whether you own or lease some or all of it, that so long as you have a possessory interest on the amount of property outlined in the ordinance, that was sufficient to, to comply with the ordinance. But as I submitted before, we would love for the permit to be issued so that it doesn't even, question sort of where things stand, but that we also believe we have resolved the non-compliance issue as well by virtue of the lease that is now before you all.
Yes, Marcus, a question. Marcus, I haven't looked at this case, and I don't have a description of the property that's leased, Jacqueline. Just assume, for the sake of this question, that the parcel is an acre under this Court of Appeals decision, 0.33 plus 0.7 equals an acre. Where's the board then?
Well, I mean, our ordinance does say if you have an acre of property, animals are allowed. So, I mean, that's more of a legal question than I can say.
Right, but if in fact I were to opine that they have a possessory interest in an acre of property, a contiguous acre, I guess, of property, then I assume under our ordinance that they've met the requirements, right?
Yeah, our ordinance says you have to have an acre of property. How that's determined, I don't know. I mean, of course, you know, if you live in a subdivision and you have 0.33 acres, that's what we go off of. We don't go off of a leased 0.7 acres. We go off of what your property, what you actually own.
But we wouldn't have to get into special exceptions or anything else if they in fact had an acre.
If that parcel was 1 acre, yes, sir, that's correct.
Okay. Yeah. So then we don't have to get into the Fair Housing Act, which I have questions about that. But it seems like the first point of business is I've got to look at this case. I've got to see a description of the leased property. I can't make this call on the fly.
Understood, and it is with regret that I wasn't able to meet the deadline.
I understand. I mean, maybe we can we postpone this decision until the next meeting? I mean, I've just got to be able to look at that case. I need a drawing of the leased property.
Sure.
And make sure that it's all compliant. Mm-hmm. And there may not be any need for the board to take action.
And I thought you might take that position. So if we are certainly willing to accommodate whatever y'all would like the process to be, and if it means reconvening there, you would find no objection from the appellant in this matter. We certainly want you to be able to make an informed decision. And again, you know, I hate that we weren't able to equip you with that today, but certainly we're understanding if you, in order to feel comfortable, need a little more time.
We do have other parties here, so I would continue with the hearing, and then if something changes between now and then, and they don't want to make a decision until later, that's fine. But we don't have right parties.
Yeah, I get it. I understand. I just can't make this legal decision as I'm sitting here right now to advise you whether or not this lease is sufficient.
Like for the lease to be sufficient, what is the time limit it needs to, I mean, is there a period of time it needs to cover? Yeah. Is there an amount of ownership and control over the property that you've actually got to have? Those are the kind of things I was wondering.
Sure.
Yeah, I mean, I got to read the Court of Appeals case first that Jackson's referring to, and then look at the lease. And I do need a drawing of where this lease property is.
One thing that we don't have in the lease, but that we can certainly supplement the lease is, it just references the 0.7 acres, but if we need to draw that out then and put an attachment that shows, I'm happy to, I mean, I can do that by this afternoon and email it to you, Mr. Coleman.
Yeah.
I mean, that's just, again, to satisfy whatever the, the county may need. And to Mr. Ross's question, it gives her the rights to use it consistent with this purpose. I mean, she wouldn't be able to go in and build, a guest house on it, but she's allowed to use it in a manner consistent with, chickens, grazing, and for therapeutic, non-commercial, non-agricultural purposes.
Yeah, I mean, I think if I opine that the Court of Appeals case as applicable to this lease and our ordinance is sufficient to give them the 1 acre, then it sounds like there's no.
It's a given.
Then we're fine. If not, then we get into the Fair Housing Act and all the other issues and special exception.
Okay.
But we can, as Marcus said, go ahead with anybody else that wants to speak, and then.
And for a point of clarification, because I have never had the privilege of coming to you all before on an appeal of this nature, I mean, do you typically like to hear from kind of the parties for or against? I mean, I've got Ms. Stebley and then her husband, the other property owner, Mr. Stebley, Mr. Stebley's mother, Ms. Stebley's mother, and then I believe that's all we have.
I'll leave that to Mr. Cumbus and Marcus, but Mr. Taylor had a question.
Why, considering the original request to the Planning Commission is basically totally obsolete, why isn't this taken back to them to reconsider, considering the new facts? And is this are the two parcels contiguous or not? I've not heard that.
Yes, they are.
They are. So the chickens or the Steebleys can walk daily?
That's correct. Right now, they would just put a gate on the fence that they have, but it is, the property lines abut to each other. And so if you took the .7 and then added it to their .3, it would make, a total of 1 point some change.
Well, Marcus, do you think this should go back to the planning people, or should we hear it?
No, sir, it's been appealed to you guys, and y'all make the decision, so I think this is the proper channel.
Yeah. Okay.
Yeah, right, and it is an odd situation. I mean, it's appeal on one reason. Things have changed between the appeal. I think our advice would be to the board and to the planning commission, and as we give our advice, we'd say, okay, Marcus, what do you want to do now? Our opinion is X or Y.
Right, then if that was the case, it'd be allowed by right, so
Yeah.
it wouldn't need a special exception. My question would be, is there...
Oh, is that it right there? Okay.
Yes.
If this is the property, as you see on the screen, is there a fence that incorporates that .7 acres, or
So,
is it
no,
just...
and I don't believe that the Sinkerfeld case requires it to have that level of delineation. She just needs to have an actual possessory interest to the property that makes up the deficit between what she has and what the ordinance requires. And so, I don't know that, so long as it's contiguous to Mr. Taylor's point, I don't know that it matters where the .7 acres is, so long, or that a fence would be required. Ultimately, what we're looking at is just additional sort of grazing, free-range area, and that the coop would remain where it is, although the coop is the kind that has wheels, and that you often do move those around just to, for good kind of chicken hygiene. And as I say this as somebody who, I also have chickens. I have more chickens than Miss Debley does, and so, it's, and on probably less property. Don't tell the new board of Alderman of Ocean Springs. I think they like chickens though, so that's okay.
Of course, there's nothing we can do about it now because this is the ordinance that was adopted, but just so you know, the ordinance that we're redoing, there will not be chickens allowed in a platted subdivision. So we're taking that 1 acre out of that new ordinance.
So let me ask this. So I thought in residential zoning, R1, 2, 3, 4, anything that was on residential didn't allow for farm animals.
It doesn't unless you have an acre or more property.
So in so if we have an R1 lot that's an acre and a half in a subdivision or an old subdivision like this, they'd be allowed to have a horse there.
It would be allowed. That's what we're changing in our new ordinance.
Yeah, we got to change it.
But right now, this is what's adopted, of course.
Okay.
One more question. If that .7 is not fenced in, then you're going to open the door for animals to go in and kill chickens.
Well, I think, just like Jacqueline explained, that's not part of the Supreme Court decision, is that correct? That it has to be fenced?
So, right, there's nothing in Sinkerfeld that would tell you.
Just have to have possession.
But I think that to your point, it's more of a practical matter. I mean, certainly nobody would want to put the chickens in a situation where they would be endangered. And so it would be either supervised grazing, or they make, these sort of like mobile grazing units where it's almost like a fence on wheels that you can kind of put them around so that they get access to fresh grass. Because if you know anything about chickens, it is that they're really good at killing grass. And so you have to almost kind of rotate them around so that they have access to grass and bugs and all the good stuff that's in there. And then they fertilize the grass, but if you leave them on that plot of grass too long, then they will kill it. But they make these little mobile kind of grazing units.
Okay. Okay.
All kinds of chicken, except once you get into the chicken world, I'll tell you, I have learned a lot in the 2 years that I have had my chicken. So what I would like to do, if it's okay, Mr. Colmer, is to reserve any additional time to discuss the merits of the Fair Housing Act argument, subject to the determination that you make at your convenience about whether this renders moot the necessity of those arguments. Would that be okay?
Yeah, that's fine with me. But I think, Marcus, if you, and Mr. Cummins, as far as those that are here that want to speak.
Sure, I wanted to.
Let's finish up.
Right.
Yeah, I mean, let her, so do you want me to continue?
If you have anything else you want to say, otherwise I can bring
I don't think we have to get into the Fair Housing Act.
No, otherwise.
Unless
Mr.
we have to get into the fair
I'm happy
housing
to
act.
answer questions at the end, and I would like to request the.
We'll bring you back up last.
Okay, thank you so much.
All right.
That's, you knew where I was going.
Okay. Ms. Stebley, y'all can come up if you would like.
If you have anything to add, it's not, I mean.
Do y'all want to add anything? Does anyone here want to speak for this? That is my comment.
I don't really have anything to add. I was just gonna say, I do have a numerous.
Come on up and get to the microphone and give us your name and address, please.
My name's Jamie Stebley, 13809 East El Bonito Drive in Gulf Hills. I was just gonna add that I do have a significant amount of letters from surrounding neighbors that are all in support.
Are those not part of the original file, or are these new?
They are.
Okay, we do
This
have-
is the only one that my neighbor texted me this morning and stuck it in the mailbox, but he said that he emailed this to our supervisor, Mr. Troy Ross, in the Jackson County Board's Attorney Office.
But you should.
But this was
you
new
should
to
have.
me, but that shouldn't be new to you
If
guys.
it's something new, we need a copy of it.
This, I don't,
You can just go ahead and give them that.
I'll let the board see it, and they'll give a copy back.
Okay. Anyone else here to speak for this? Is anyone here to speak against this application? Come on up, sir. Give us your name and address, please, sir.
William Thompson, 13805 East El Bonito Drive.
Go ahead.
First thing I would say about the property that's behind them, it's all flood zone. There's a huge drainage ditch that's draining all the new properties east of us between their house and the house next to them. And it goes through that part behind them, and it's all flood zone, and it's draining a big part of the neighborhood. So, in the south side of Chris's house is also flood zone. So you're moving the chickens over into the flood zone, and all of that stuff that generate is going to be washed down through there into the bayou. And how can you use that type property to raise chickens on? It's not feasible for it. The second thing, you're talking about that Fair Acts Act. One of the things you said was physical. You don't just say mental, it was physical. I can tell you what they've been doing to us is beyond. I'm a cancer survivor. 8 years ago, they removed my stomach because of the cancer. At that point, I had about a 27% chance of surviving. 5 years. They measured my 5-year survival rate. And what they've been putting us through with these chickens is horrible. The neighbors around us are not saying anything, but they don't. Ones that are immediately around us are not saying anything. But they don't think it's right. Most of them laughed when they got the letters, because it seemed ridiculous at the point. And also because there's a thing that retribution is one of the things we've faced in all of this, and that's one of the things we waited so long to do anything about it. And our yard was there, and it became their yard because they refused to stop. They put it up, the chicken coops up against our fence, and the only way they could get through the backside of it to work on it was through our fence. And they work at night most of the time, in the middle of the night. We had problems with our lights coming on at night. Our motion lights. And it would be after 10:30 at night when they would be back there working on them. And they did it whenever there was a storm coming, whenever the weather was getting bad, they would come out and do things to it at night. After our bedtime. And we got to the point we had to quit turning off the motion light. We turned the motion lights off because they were always back there. Now they got headlights, and the headlights flash through our windows. When we had the animals in our yard, we could open our blinds from our bathroom, and there was somebody standing looking for the animals in our yard. Or we look out our back window, and there's the animals. There's somebody out there looking for the animals in our yard, under our deck, in our flower beds, or wherever. And it got to the point that we could no longer stand it. And then we complained. I marked a yard, my property line. And because I was told not to come back, and I'd been keeping that side, their yard on the north side is very small. And I usually kept it cleaned out or mowed or whatever, and she told me not to do it anymore. So I put a property line marker from one end of the property to the other, so that when I cut the grass, I came down that property line. We first put no trespassing lines to stop it, but they ran over them with the garbage cans when they dragged the garbage cans through our yard out to the street. Then they started pulling up our markers, our property line markers, and throwing it in our yard. Each time I put it back down, I put it down before I cut my grass, and I put it back down, and I got called an asshole because I was putting it back down, and I've never been called an asshole in my life. But it's been one thing after another. We were told that it wouldn't be but 4 chickens to start with, and no roosters. And it wasn't long after they were there, it was 7 chickens, because they had a rooster in there that was with the 4, and they got rid of the rooster, but they got 4 more chickens. So it just, we've both been, my wife and I have both been in bad health for the last year. And, well, 2.5 years. She's had to have surgery with her knees, and then it turned bad. We've both had deaths in our family. Her sister died first, and then my sister died. The day after I buried my sister, I was standing there cutting my grass, and I was called an asshole again, but because I had put my fence property line marker back up. If you're looking at that Fair Act, it said physical too, not just mental. And what they're doing is causing us much duress because of our physical conditions. So which do you measure? What she's saying is her condition, or what's our condition, and which is having the most effect? And to us, it's the effect it's having on us. And animals. We were out at 4:30 one night because we had a raccoon on top of our head, on top of our house. It had been 2 days in a row that we had them up on top of our house. We've had foxes. We get foxes in our yards now. We get possums in our yard. And the squirrels go wild whenever they start eating their feed. So you can't just look at what one mental condition is without looking at our physical condition and the effect whatever they're doing is having on us. And we don't need the chickens. If half of their yard, the south side of their yard is already flood zone, and this property they're pulling in is all flood zone, and there's a clear draining area for the east side of our road, and it's going straight to the bayou. That's not the type of property you raise chickens on to start with. I just want you to consider that in whatever decision you make. Please don't allow what they're doing to us to continue.
All right. Thank you, sir. Appreciate you. Is there anyone else here to speak against this application? Give us your name and address, please.
Okay, thank you. Nan Thompson, and my address is 13805 East El Bonito, Ocean Springs.
Okay.
And I'm Bill's wife, and we are the neighbors of the Stebleys, and everything was congenial and for several years, and then they approached us about having chickens, and we said we don't want them in our yard, and from day one they were in our yard, and we had to call many times to get them out, to get them out of our yard. It was just repeatedly, over and over and over. So the fact that was stated that this just came up as a complaint lately, those chickens in October will have been there 3 years. We were not aware at the beginning that there was a county code that said if you don't have an acre of land, you don't have domestic animals. We put up with their cat, which, by the way, we have asked repeatedly over this time to keep the cat out. The cat still comes in our yard. We probably have 250 pictures of the cat in our yard. She's there all the time. There's no attention paid to it. But back to the chickens, we were asked, we were told, and we did not realize there was a county code at that time. Had we realized that, we would not have gone as far as we did. But we said, don't let them get in our yard. Well, they were in our yard. And yeah, it has become an issue because we tried. We gave them every benefit of every doubt for over 2 years. We asked them, keep the chickens out. Chickens didn't stay out. We asked them not to work in our yard, but the only way they had jammed that coop up in the back of the properties between both of us, and there was no way they could work on it without coming in our yard. And that meant disregarded any time. We said, if you have to come in here, we let them at first. And that worked out. They came in and they did. And so we finally said, you know, you need to just work on it in your yard now. We've allowed this, and now you need to just do it in your yard. Well, that didn't happen. And they came at night. Well, could you let us know if you're going to come at night or when you can? Never happened. I mean, everything that was presented to us was not enforced. Therefore, we feel like if this use permit goes through, it's not going to be enforced. They're going to do just what they want to, because we've been the victim of that for over 2 years now. And yes, we did. We were so sick this past year and had so much to deal with, and we were enduring things like Bill mentioned about property line and so forth. We finally got the fence up, but that didn't stop the retribution that we got from them. It was just acts of unkindness, and we had tried everything to be kind and lenient, and accommodating. But this just mushroomed into other acts until it was beyond us. And so after those things happened, and I know you can't address those things, but I would encourage you not to stamp your approval on it as well, because we have suffered from it. And after those things began to take place, and we just tried to stay our distance. But yeah, have you ever been sick and listened to a rooster from 4:30 in the morning till after dark at night? Constant, and chickens fluttering and making noise? Have you ever walked out on your porch and the smell of cat urine was so bad you couldn't enjoy it, and the chicken dander was so prominent in the hot weather that you couldn't enjoy it? I mean, I could just go on and on about things. So it's not just a matter of one person and what they may be experiencing. It's a matter of a lot of things. And furthermore, the issue was, are you supposed to have this on less than an acre of property? That's the county code. That's what needs to be enforced, and that's what we don't understand. If that's a county code, that's pretty clear. I mean, you don't have to have a lawyer or anybody else to figure that out for you. That is the code, that's the enforcement. And that's only fair to all of us, not just me. That's fair to every one of us. It's for other neighbors wanting this. They do not. We have plenty of new people out there thanks to the building, and let me tell you, they do not. They are petrified that if this goes through, then this little house behind them, they're new too, and these people are new also. And they don't want these people next to them to go and get 5, 6, 8, 10 chickens. They do not want that. They're not going to come to this meeting and tell you that because they've seen what's happened to us. They're not. So it's a much bigger parameter here than you think. But the issue is, do we enforce what is already a county code? That's what came to the Planning Commission. It's a county code, and it shouldn't be violated. But it's been violated more than one time. It's been violated several times in this particular instance. So is it not going to be enforced, or is it going to be enforced? It's not a matter of adding land to it now. That's not the issue. The issue was, could this be done on the land that is there? No, it cannot. So that's the real issue here. And no, and she's had 3 months extension since the Planning Commission. Yeah, they moved the coop, but that didn't remedy the problem. You're still doing what the code says you're not supposed to do. So if we're going to be fair to everybody, and that's everybody in the county, then we don't start making these exceptions like this. And one person has to endure what somebody else really wants. That's not fair. There are plenty of people in this county that are upholding the code. Plenty. There's plenty in our neighborhood that are, but there's always going to be those that don't want to. And they want to go around it some kind of way. So we come up with these other things. And that land they're talking about, as Bill said, it's in a flood zone. It's not fenced. It won't be fenced. If she wants to let the chickens out, then there we are. We're back to the same problem. So we would just appeal to you, not just consider one item here. This is mushroom into other things, and it's just a way to keep walking with and getting what I want. And it's not fair to all of us that do live by the codes. And we try to live by the codes and uphold the law. But this has just mushroomed into way greater than that. So we would appreciate you thinking about all of us that try to uphold the codes, and ask you to uphold the codes with us and deny this. Thank you very much.
Thank you, ma'am. Is there anyone else here?
I would like for the cat to stay off our property too.
Is anyone else here to speak against this? All right, Ms. Rigney, you have a rebuttal.
All right, gentlemen, thank you. Just to conclude, at least on sort of this portion, to allow Mr. Palmer the opportunity to review what was shared with him this morning. You know, I don't intend to dignify any of the, you know, personal attacks on the Stebleys with response. Ultimately, you know, a dispute like this between neighbors is not relevant to the decision that you're being asked to make. And while we're not without compassion for the challenges that, you know, all of us endure, particularly as we get older, that shouldn't influence, it shouldn't influence a situation like this. And we heard a lot about strictly enforcing ordinances, but you can't strictly enforce an ordinance if in doing so you violate federal law. And that was the basis for our arguments before the Planning Commission, that there was a need for a special use permit to be an accommodation under the Fair Housing Act based on the evidence that was submitted to the Planning Commission. And I would reiterate that by failing to undergo that analysis in, you know, in really any substantive way, the Planning Commission committed error and should be reversed. We believe that the record has enough to establish that a reasonable accommodation under the Fair Housing Act is appropriate under the circumstances, and as a result, a special use permit should be issued. But to even, we've almost eliminated the need for a formal finding there, although we would still, you know, love to have one where a special use permit is granted, because the Sinkefeld case and the lease that we have submitted to you this morning resolves the non-compliance with the ordinance in a way that makes this honestly a moot point as it relates to the board. I mean, conceivably, the board could affirm the decision of the Planning Commission and find that a reasonable accommodation under the FHA is not necessary. But by virtue of this lease, there's now, you know, a matter of right for Ms. Stebley to maintain these chickens. It doesn't matter. Sinkefeld doesn't tell us that it matters if the property has some wetland, doesn't have wetland. I mean, we live in South Mississippi. There are an awful lot of wetlands here, and we're still able to use them, at least for certain purposes. Maybe you can't build a home on a wetland, but that's not to say that they can't be used in other ways. So that really should not, that shouldn't influence either the decision that you all make, which is either that Ms. Stebley is entitled to a special use permit as a result of a reasonable accommodation of the FHA, or that this issue altogether has been rendered moot because the Stebleys have found a way to come into compliance with the ordinance. I don't think you have to worry about this setting some scary precedent in Gulf Hills or anywhere, because it's sort of a unique situation that there is vacant land to the side of Ms. Stebley's property that would allow a lease like this to occur. I mean, this isn't a typical thing, even in the county, that you should expect to see. So I don't think you have to worry about some precedent that you have to contend with down the line. But at least right now, I believe we've presented two routes for the board to make a decision that will allow Ms. Stebley to maintain her small flock of therapeutic chickens that does not include a rooster. There was at one point a rooster, I believe they hatched it, but when it crowed, it was gone. So it lasted just a few minutes there. They don't intend to get any roosters. They're certainly agreeable to not having a rooster. They don't want to hear roosters either if it means anything. I'm happy to answer any questions, Mr. Cumbest, or to the rest of you all. Mr. Calmer, I mean, I'm happy to obviously answer any questions down the line once you've had a chance to maybe dig into the case a little bit more.
Right, I was just going to ask the board to make a motion to recess this until the next regular board meeting. And if my opinion is that the Supreme Court case or Court of Appeals case is not applicable to this situation for whatever reason, then I guess we'll go through the fair housing analysis at that point.
Okay.
And pick up where.
Do we know the date of that, just to?
What's the date, Mr. Cummings?
August 4th.
4th.
Okay. And I would add just one other thing. This was, she requested time to come before you all, not because of anything having to do with her schedule, but it was the byproduct of my schedule, which can be a little intense sometimes. So it wasn't Mr. and Ms. Stebley trying to find extra time. It was me being busier than I would like to be. So with that, I will, again, I'm happy to answer any other questions. Otherwise, we'll just be prepared to reconvene on this.
Anybody have any questions? I just want to make a comment. So say Mr. Colmer comes back and says that this is not, that lease plus the property they own meets the requirement and there's no reason to be here for a special use. Would they be willing to purchase like one of those rolling pins so that when they utilize that other property?
Of course, yeah.
They would
We certainly
actually be
are
inside
mindful
some type of a coop
that
or a
chickens
pen
have to be contained.
So they're not just roaming free? If
Sure.
that's the case, and they don't have to come back.
Yeah, I mean, absolutely. Whatever needs to be done to ensure that the chickens can be reasonably contained, you're not going to find an objection there. So we definitely would be cooperative in whatever constraints are offered by the board. Yes, sir.
I would like to ask my question again.
Okay.
Will basically the 1 acre area be fenced in to protect these emotional chickens from predators coming in and killing them? If the answer is no, how in the world could we support it? If the answer is yes, then I would think we could support it. Now, is that answerable? Will it be fenced in?
The answer is that no decision is made on whether it would be fenced in yet. And I don't believe that the Sinkefeld case would require that. It simply requires that the property owner have a possessory interest in whatever the threshold amount of acreage is. And, in the Sinkefeld case, it's not as if, and I can't remember if it was 3 acres, and that the horses then had access to the 3 acres. I mean, the ordinance does not specify how you use the acre. You just have to have the acre in order to have chickens in this case.
You're opening up the discussion of what is emotional support.
Sure.
If you're going to have something out there that at any time, day or night, a animal can come in and kill your support animal, I've got to question, how can that be a support animal?
No. So let me So my point would be, Mr. Taylor, hypothetically at least, the Sinkefeld case wouldn't actually require the Stebleys to relocate their chickens. They just have to have a possessory interest of at least 1 acre to maintain them for purposes of complying with the ordinance. And so as a result, again, hypothetically, and this is why a decision has not been made on how the chickens may access that additional grazing area, but certainly it would be done in a way that protects the chickens. Nobody's going to subject the chickens to just free ranging on an old golf course, because at a minimum, you might lose your chickens. They may just wander into the woods and you never see them again. So that's not a consideration for Mr. and Ms. Stebley. But what I would say is that with Sinkefeld, by having this 0.7, grazing lease that creates a contiguous 1 acre possessory interest, it does not matter that there's no guidance from either the ordinance of Jackson County for an R1 residence or Sinkefeld that would say then that you have to utilize the full acre for purposes of allowing the chickens to graze. You just have to have the possessory interest in at least an acre, and then you can sort of make it, it really would not require them to do anything different with how the chickens are housed now. But of course, if they have access to the extra property, then they want to explore how they might use that in a way that is safe. Does that answer your question?
Not really. It opens the door of why are we even using rationale? You don't need that rationale anymore because it would be legal to have chickens or whatever in your 1 acre, even if you're going to allow them to be murdered, okay? So that is no longer part of the equation.
With respect, I would disagree in that.
You would disagree?
Yes, sir.
Okay.
And the reason is because we have found a way to technically comply with the ordinance, and it would not require a change to the way that chickens are currently being maintained, which is in a fenced-in yard in a safe location. Now, it would obviously allow the opportunity to begin exploring how to leverage that additional 0.7 acres for the benefit of the therapeutic animals. But the reason a decision has not been made yet on how that's going to work is because, one, we're focused on keeping them safe, and then we needed to understand what the position of the board would be. I don't think these are two mutually exclusive arguments. She can have therapeutic chickens and comply with the ordinance in a way that alleviates the need for you all to engage in that analysis, and those things can coexist. That's all I would say.
Jack?
I don't think, you know, in my opinion, I don't think that's the way our ordinance was written. I don't think that's, I mean, I think this is circumventing the ordinance. And it may stand up based on the court case. It might say that you can do it. But I know that's not the intent of our ordinance. And if this is allowed, I think this opens up a whole can of worms on lots of other property in Jackson County.
I've got to read the case in conjunction with Marcus on our ordinance and see, are our hands tied, or are they not, or do you have some discretion?
And that's why a lot of we're rewriting the ordinance to take it out of platted neighborhoods because of this case right here.
I agree.
So this case may fall into that hole where it kind of slips through because we can't. And that's why we're in the process of rewriting the ordinance to change the way it's worded.
And that's what I wanted to say, that, you know, the board probably needs to vote for or against this use, because once that new ordinance is adopted, even though they have an acre of land, this is still in violation because it's a platted subdivision. So if the board doesn't vote to approve it now or deny it, they're going to be in violation once the new ordinance is adopted.
Yeah, but they'd fall under a grandfather at that point. I mean,
there's no grandfather.
Not if there's not a special use granted.
If you're doing something for 3 years, you're going to fall in. I mean, and no one said anything, and nothing's ever been filed. It's like utilization of property over a certain period of time. Eventually, you have a prescriptive easement. I mean, I don't see how that's much different. But my question was going to be is, if I own an acre right now and it's R1, I'm allowed to have some type of animals like this.
Correct.
Is there anything that says that I have to let them roam through the whole acre, or can I fence them into a particular part of that acre?
Nothing in our ordinance. There may be something in maybe animal control's ordinance, but nothing in our ordinance.
The ordinance is silent.
They
It
need to
just
be
says.
fenced somewhere, right? They can't just roam free.
That's what you said.
But if they're fenced into a part of it,
You're correct on that, Troy. I don't think it's required if you have an acre, that you have to let them roam.
that would
the
make
whole
it
acre.
by right, and I think we need to let Jimmy review this and see where it is.
Well, and to Mr. Fulton's point, the Syncopalt court does go into saying, is this not just a way to circumvent the ordinance? Is this not a sham? And the court ultimately landed on the fact that there's a valid legal possessory interest that, you know, for better or for worse, based on how the ordinance is written, is why they reached the decision that they made. I certainly appreciate how that perspective can exist. And in this case, sure, we're trying to figure out a way to keep the therapeutic chickens, whether it's under the FHA, whether it's by creatively coming into compliance with the ordinance. I mean, we are very transparent about the objective here. And however we can make the decision of you all easiest to allow us to achieve the objective that we have, then that's what we want to do. We're not trying to be too cute by half, but you know, when Bubba Pierce tells you there's a Court of Appeals case that is pretty on point to what you have, you just don't look a gift horse in the mouth, right? And so we're here. We think our argument on the Fair Housing Act is sufficient for you to issue the special use permit, particularly in a situation where these chickens have been there for almost 4 years without issue until recently. And I would submit to you all that some of those particulars really are just not germane to the decision that you're being asked to make. But I recognize it's not without complication, and you want to be mindful of the decisions you make and how they can impact the future decisions that you make in the future. And I would just say, in my attempt at being reassuring, that this is such a narrow issue that I would be very surprised if something as structured the way this one is comes before you all again. And with that,
and we're rewriting the ordinance so that
it
wouldn't be an issue in the future. It almost to me feels like we're correcting something that we realize is a loophole.
Mm-hmm.
That's what makes me concerned with this, because we've acknowledged there's something wrong with it, or else we wouldn't be rewriting it.
Sure, and I appreciate that. And I mean, it's interesting to me that in the city of Ocean Springs, you can have chickens, whether you're R1, and then in the county that they're restricted. I was actually surprised to learn that, because I'm thinking, this is the county. Of course you can have a few chickens. And so it's not always intuitive, I guess, on how the laws are written. And I respect, obviously, the effort that y'all make constantly to try to keep these laws evolving, because sometimes things are only clear with the benefit of hindsight. But in any event, I believe that Ms. Stebley is entitled to maintain this flock of chickens that she has had. Many of them have been there for almost 4 years without issue. They're not loud. I have more chickens than she does. That as long as you maintain a tidy coop, they don't stink. I mean, my dogs are stinkier than my chickens are. And so it's just the nature of having animals. Was I supposed to sound
All right.
or no? That's,
Thank you, Ms. Reedy.
Okay, thank you so much, everyone. Appreciate it.
Thank you.
And I agree with Brian. I don't think it was the intent of the ordinance. But it's meetings like this that we find that we need to tweak things, in our ordinance, and we're in the process of doing that now. So this is something we can fix along the way.
Okay.
But I do believe, and I don't know that there's a grandfather. Jimmy, is that the case for?
I don't know one, but that's something I gotta look at as well.
Because if it's not approved or denied, I believe they would be in violation once the ordinance was adopted.
Okay. So when is the ordinance scheduled?
We're thinking somewhere around October, November.
Well, we're going to have that meeting way before that. That meeting's going to be 3 months before that.
Come again?
Our next meeting's going to be way before that.
I'm saying if you don't approve or deny it.
Right.
If you just go by the 1 acre, she would still be in violation once the new ordinance is adopted, because that would come out of platted subdivisions, period. So that would still be a violation.
Okay, so you may have to vote on it on that day, but you would have the idea. I don't know. I don't necessarily agree with that.
I'm ready to make a motion today to go ahead and institute the subdivision requirements that no farm animals be in a platted subdivision. I'm ready to make that motion today.
Well, that's
this is going to get out of hand. I can tell you that right now.
Well, that's going to be put in the ordinance, and that'll be brought before you also.
After today, no matter whichever way this goes, we're already seeing this. I mean, we've already seen it 3 times this year.
Oh, I deal with it all the time.
And this is just not what residential neighborhoods are set up for. It's just not. I mean, if we're going to keep allowing density in these neighborhoods, 90-foot, 100-foot lots or whatever, that's not dense. That's too close together to allow any kind of farm animal. Most of the time, it's too close for dogs and cats. So I'm just saying, if we're going to start allowing these smaller subdivisions, then we've got to put some more emphasis on the neighborhood in general when it comes to animals. I mean, it's not. I mean, I have animals at my house, but I keep them controlled. I don't let them roam the neighborhood. So these depending on the animals, we've just got to keep it under control. But these neighborhoods are going to get. It's just we're going to have more of this. I see it if we don't put something out there now to stop it.
Well, I think we have to tweak our ordinance, but I do agree with Brian. I don't think that was the intent.
Okay. Thank you.
Motion to recess this appeal until August 4.
It's over. It's okay.
So moved.
Yeah. Second.
Okay.
We have a motion by Mr. Ross, a second by Mr. Beausarge. All those in favor say aye.
Aye.
And opposed, no. All right, that's it. Thank y'all. All right, I need a motion to return to executive session, isn't it, right? Yeah.
Oh, yeah, we got to go back to it. Yeah. That's all that's left.
Yeah. You made the motion, Ken.
I did.
Yeah. Mr. Morris, second. All those in favor say aye. Opposed, no. All right. We're going back into a minute, George.